With the end of the year fast approaching, now is a good time to take a look back at some of the key developments in 2018. On the international front, employers have had to get to grips with a number of gender-related topics, from gender pay gap reporting to investigating an increasing number of sexual harassment complaints arising in the wake of the #MeToo movement. Closer to home, employers have been grappling with GDPR, mandatory retirements, and the complex question as regards when an employee is entitled to be legally represented in an internal HR process. The issue of mandatory retirement and the so-called grey ceiling has been a taxing issue for employers in 2018. The fact is many employees want to and indeed need to continue working until the state pension becomes payable, and that in turn has led to an increase in the number of challenges to mandatory retirements. Earlier in the year, the Workplace Relations Commission published a guide to longer working, and while not legally binding, the Workplace Relations Commission and the Labour Court will have regard to the code when it comes to adjudicating on the legality of a forced retirement. So for those employers with older workforces, this really is essential reading. One of the most significant case law developments in the year was the recent Court of Appeal judgment in McKelvey v Irish Rail. In that case, the court had to consider the circumstances in which an employee is entitled to be legally represented in an internal disciplinary process. And what the court held was that an employee is only entitled to be legally represented in exceptional circumstances. So I've no doubt much of 2019 will be spent with employers and employees arguing over the circumstances that constitute exceptional circumstances. Finally, no 2018 look back would be complete without at least a passing reference to GDPR. While employers spent most of the first part of the year getting to grips with GDPR compliance, thankfully most of the heavy lifting is behind them. What employers are now having to deal with is processing of employee data and responding to data subject access requests in a post-GDPR world. The bad news for employers is that the Data Protection Commission has received the highest number of complaints ever this year, and it really is only a matter of time before fines are imposed. So for that reason, our key advice to employers is remain as vigilant as ever when it comes to employee personal data and make sure GDPR compliance is a key business priority for 2019.